Evidence from Glencore.
Connection with the current president, Mr. Ramaphosa, and that Glencore intended to leverage his influence in order to negotiate a price increase with Eskom once the acquisition of OCH had taken place. What would be your comment to that?
I think that allegation is preposterous, and I can't understand how and why someone would think such a thing. The reason why we did not do a comprehensive due diligence is the following. And I'd like to point you to my second statement. We're going to have to go to page
It's page 322 on the hard copy.
Thank you very much. Page 322 and paragraph 6. 323.
Yes, on the soft copy. Thank you. That's correct.
Correct. So let's just go back one step. Why did we not do a comprehensive due diligence? This is not an uncommon strategy when procuring a company. One has to assess the risks associated with not doing a comprehensive...
I'm sorry, Mr. Ephron. You said 323. Is there a particular paragraph that you want me to look at as you give evidence?
Paragraph 6.
Okay, all right. Continue.
So there are two mechanisms in terms of buying a listed company. There are two ways in which one can do it. One can approach the company directly and attempt to buy the shares from the company once they approach the end of their shareholders, or you can approach the shareholders directly and through a series of private transactions, obviously through the market, you would be able to secure a certain amount of shareholding in the company. So the reason why we did not approach OCH directly was because had we done so, OCH would have had to put out a public notice, a SENS announcement that its share price could be affected as a result of a certain transaction. So we said, in order to ensure that the price remained competitive, and we knew that there was potentially a competitive process out there, a number of prospective buyers were interested, we elected to approach individual shareholders directly. So as a result, we could not enter into a non-disclosure agreement and go ahead with a company and kick every tire. We felt that we had sufficient information, sufficient knowledge about the company through our industry knowledge, and in addition, the pre-listing statement, which I previously mentioned, which was 300 pages long, gave us substantial amounts of information around the company. So we did not kick the tires. We did not know every single asset within this company, but we certainly had a pretty good understanding. In going to your question, Mr. Selecki, there is not an iota of evidence that points to the fact that Glencore in any way wanted to rely on the relationship with Mr. Ramaphosa as our shareholder in order to change the contract price. It's ridiculous. We can show, the commission has interviewed a number of Eskom directors, a number of Eskom employees, past and present, and nowhere has it ever come up that Mr. Ramaphosa was involved in any discussion or negotiation around the CSA of OCM. I go one step further. In paragraph 9 on page 324, I'd like to please read it out.
Yes,
I never asked Mr. Ramaphosa to intervene on behalf of OCH or OCM in any matters relating to Eskom or the CSA, and to the best of my knowledge and recollection, he never did so.
Were you?
So we strongly deny this allegation.
Yes. Were you personally involved and directly with Eskom in regard to the co-supply agreement?
Yes, every step of the way.
Yeah. Now, the acquisition was completed in March 2012, you say in your statement, which you have now confirmed under oath. And you do say that, I think it's around July 2013, OCM decided to invoke a hardship clause. That's a little over a year later.
Maybe before you go that far, Mr. Seleka, Mr. Ephron, is it in 2011 or early 2012 that OCH acquired OCM?
Mr. Chairperson, it was a series of transactions. So there were a number of transactions that we entered into
Yes.
between June 2011 and March 2012.
Yes. So the point at which you could say, it could be said that the acquisition of OCM by OCH was complete, would it have been in March 2012, in your view?
So just to correct you, Mr. Chairperson, it was not the acquisition of OCM of OCH. It was the acquisition by Glencore, Lexshell, and its other shareholders that finalized the purchases of OCH by March 2012. Correct.
Yes, but as I understood the position, I thought earlier on you said the Glencore acquired OCH. Or is the position that OCH,
yes, that's what,
OCH already held 100% of shares in OCM before Glencore approached?
Yes.
Oh, okay, all right. So OCH,
yes, Mr. Chairperson.
OCH was
yes,
at all material times in control of OCM, and then Glencore just
that's
acquired
correct.
the shares. Is that right?
Of OCH.
Of OCH.
That's correct.
Yeah. Okay, no. But the point in time when it could be said, or rather, let me say, what is the point in time when Glencore had acquired OCH, the shares in OCH?
I think you're referring to at what time Glencore and its partners had control of OCH.
Yes, that's what I'm talking about. Yeah, had control of
that.
Yeah.
That would have been in and around March 2012.
Okay, all right. Do you know what Mr. Ramaphosa's position was in that regard, whether in government or in the ruling party?
At that point in time, my recollection was that he was not involved in government.
Yes. And then in the party, was he already deputy president?
My recollection, and I really do not have the exact dates, but when Mr. Ramaphosa divested his interest in all his mining ventures, this one included, was in paragraph 13 of my first statement. and that is on the 22nd of May 2014. So it would have come after that. Mr. Ramaphosa would have become deputy president only after that date.
That is deputy president of the country. But what about deputy president of the party?
That's correct.
What about the deputy president of the party? Can you recall when he became that?
My recollection is that he was not involved at all in politics prior to his taking up of deputy presidency of the country. But
yeah,
I'm sure these facts would be able to be easily verified.
I think the information in the public domain would be that he was elected deputy president of the party at the Mangaung conference in December 2012. Mangaung conference of the ruling party in 2012. I think that's my recollection, just from the public domain. Does that sound right with you, or you don't know?
I really can't confirm that.
Yes.
I seem to recall that when Mr. Ramaphosa was going to take up the position of deputy president of the country, he divested himself of all his mining and, in fact, all his business interests in South Africa. So that's what I seem to recall. I don't seem to recall anything else.
Yeah, well, he became deputy president of the country after the 2014 elections. Yeah. So that might tie up with your statement in paragraph 18 of your statement. Mr. Seleka, is my recollection about Mangaung correct?
It is correct. The date from the president's own affidavit, his election being elected as a deputy president of the ANC, it's 18 December 2012.
Yeah. Okay, all right. Now, Mr. Ephron, going back to the non-comprehensive due diligence exercise, as I understand it, that you say was undertaken by Glencore, you obviously did see the coal supply agreement that you would be taking over from when you acquired OCH and OCM, is that right?
Correct.
Yes. Now, I note that in paragraph 14 of your first statement, you say you did not, for example, or Glencore did not, for example, know how any price adjustment mechanisms in the coal supply agreement worked. Why didn't Glencore find out how those mechanisms worked? I would have thought that would be simple.
Yes, because that information was not disclosed in any of the pre-listing statements or publicly available information, and therefore we could not have known that.
Now, did you say you didn't approach, that is, Glencore didn't approach OCH, OCM directly as a company, but it approached shareholders privately? Is that correct?
Correct. That's correct.
Yes. And you say that was because if you approached the company directly, that would have triggered some notice that would have to be given, and that would affect the share price. Is that right?
That's correct.
Yes. But you did have sight of the coal supply agreement. Is that correct? You just didn't know how the mechanism worked.
That's incorrect.
You did not?
No, so we only would have had, we did not have sight of the coal supply agreement. We would only have had sight of details in the competent persons report of the coal supply agreement, such as volume, duration, and price.
Yes. Does that mean that that was just one agreement that you didn't have sight of, that you would in effect be taking over, or is the position that you didn't have sight of any agreements that you would be taking over when after acquiring OCM?
We wouldn't have had sight of any confidential agreements that OCH would have had. Only the main details of significant contracts and deals that OCH had.
Well, it sounds strange to me. I think you said it's normal to do things this way, but it sounds strange to me because...
No,
or did you not? Am I attributing you?
I didn't say it. No, I didn't. I didn't say it was normal. I just said that it happens, and it's quite common that potential acquirers of a company don't go directly to a company. So let me just shed a little bit of light. If you go directly to a company,
yes,
it takes it to the board. The board then may turn around and say, you know, why would we do a deal with one prospective buyer? Let's open this up to a tender process. Let's look at the entire market. Let's look at potentially the better value. So by going directly to a company, it's a strategy. If you can sign an exclusivity with a company, then maybe it's a good strategy to take. But if you can't, and we didn't feel that we could, then it would have opened up a sort of Pandora's box in terms of potential competition. So we felt that the strategy was more prudent to go directly to shareholders that own the shares in OCH and effect transactions with those shareholders. We've done it before at Glencore. This is not the first time that we've done such a transaction.
Yes. Okay. No, I understand that I was attributing to you something that you had not said, that it's usual, but you say, I think the line between what you say and what I was attributing to you is quite fine. You say it does happen, and you say it is common, the approach to the shareholders as opposed to approaching the company. Okay, all right. Now,
correct.
One of the reasons why, certainly from my perspective, it was important that you be called back is that certainly when you gave evidence, and maybe when other witnesses gave evidence, I had this feeling that OCM, Glencore, might have been treated rather harshly or unfairly, or maybe too firmly by Eskom when you invoked the hardship clause. Of course, when Mr. Brian Molefe came and gave evidence, and you might have had him, or you might have had the chance to either listen or watch or read his evidence, he referred to something that I said at some stage, and I can't remember whether it was when you gave it evidence or somebody else, when I questioned why Glencore had not done a due diligence, but maybe with what you are saying now, I must say why it had not done a comprehensive due diligence, because you say it did do a certain type of due diligence. It's not as if it didn't do it at all, you know. Now, but when Mr. Molefe gave evidence, he in effect said, not in so many words, but he was sending a message that says, Glencore OCM don't deserve any sympathy. To say the least, they put themselves into this position. They didn't do a due diligence, maybe we should say, didn't do a comprehensive due diligence. They took over a coal supply agreement that had this clause about price, and they then complained that this price was bringing them hardship, and they wanted Eskom to increase the price quite drastically. And he said, I refused, because it was going to be unjustified for me to get Eskom to increase the price like this. But his evidence, together with that of Mr. Koko, when the two at least are read together, also says, but hang on, if Glencore OCM felt that there was unfairness in us sticking to the price that was in the agreement had a way for them to get relief. The agreement said you can invoke the hardship clause, which they did invoke, but it says if there's no agreement, you can go to arbitration, take arbitration to its finality. And if the arbitrator, who would be a neutral person, thinks that yes, there's been harshness on you, relief will be granted. And they were saying, but at Glencore OCM, although they invoked the hardship clause, and although at some stage they took steps to pursue the arbitration route, they never pursued it up to its end. And Mr. Koko says, Chairperson, do you know why they didn't do that? It's because they knew they had no case. Because the agreement, or I don't know now, I may be referring to the settlement agreement that they referred to, defined what was excluded from the hardship clause. So he says, excuse me, he says they knew they didn't have a case of any hardship. That's why they didn't pursue the arbitration route to the end. So in other words, saying to me, Chairperson, in effect, whatever sympathy or unfairness you may have felt for Glencore stroke OCM when Mr. Ephron gave evidence here, and maybe whoever else gave evidence, was misplaced, because they placed themselves in this situation, and for the situation that they were complaining about, the coal supply agreement had an escape route being to go to arbitration, and then you could get relief. But they didn't do their job. Now they wanted Eskom to accept an increase, an unjustified increase in the way they put, certainly Mr. Molefe put it. So do you want to address that criticism? Or those that
yes.
evidence?
No, I do. You've raised numerous points, Mr. Chairperson. So
yes,
I have to try and recall. You've raised a lot of points that I thought we would individually go through, but I'm happy to do so.
Okay, what I want you to do is deal with them to your satisfaction, but Mr. Seleka might individually raise some of them, but deal with them the way you would like to deal with them.
Okay, so let me try and again give you my perspective in order to refute some of the allegations that have been made. You have to go back a step. The CSA contract between OCM and Eskom was entered into in 1993. It was a 25-year agreement. The people that entered into that contract envisaged that situations and circumstances will change over a period of 25 years. And as such, they included a hardship provision. When Glencore came into the company in June or in March 2012, we started to understand more and more about the contract. We, of course, identified that there was a hardship clause. Now, Eskom is a business and Glencore is a business. The contract had been running for 19 years. The contract specifically makes mention under the hardship provision, and I need to read this again because for some reason people seem to forget the severity of the situation. I'm referring to paragraph 12 of my second statement, and that would be on page 324. Are you with me, Mr. Chairperson?
I'll get there just now. Yes, I'm there.
So, the CSA between Eskom and OCM included a hardship clause, which specifically provided that.
And that is
and I
paragraph 12.
quote from the contract. Now, exactly, it's paragraph 12.
Mm-hmm.
In entering into this agreement, the parties declare it to be their intention that this agreement shall operate between them with fairness and without undue hardship to any party. That is the prerequisite of the hardship clause in the CSA between OCM and Eskom. So on the back of that, we instituted hardship, and we knew that it would be a long and tedious, laborious legal process with Eskom. We understood that. It was then, in early 2014, and I'm going to have to refer you, we're jumping to my first statement now, paragraph 20, and I'm going to get you to the page.
Page 4.
Page
Thank
4.
you. Page 4, okay. Paragraph 20.
Mm-hmm.
Please confirm that you're with me, Mr. Chairman,
yes,
Mr. Chairperson.
Yes, I am. Thank you.
Okay. So approximately 6 months after discussions and the hardship notice had been sent, Eskom then approached OCM to suspend the hardship arbitration and to come up with a proposal to ensure the viability and the longevity of the mine, and at the same time secure the much needed coal required for Hendrina Power Station. Why did Eskom do this, in my opinion? Is that Eskom realized that there was severe hardship being incurred by OCM, but Eskom also realized that that contract would be coming to an end in December 2018, and under a cooperation agreement, which was signed in that paragraph on the 23rd of May 2014, we agreed that we would suspend the hardship in the hope that we could negotiate terms where the original idea, and it's not exactly written in these words in my statement, was that we would recover our costs for the period 2014 to 2018, and then we would extend the contract with Eskom at advantageous prices to Eskom for the period 2019 to 2023 or 2024. So we like to see it as a win-win. At the same time, there were a number of penalties and a number of other things that we were hoping to incorporate some resolve and settlement on that. So when we looked at this and we said, can this work? Or when Eskom looked at it, they said maybe there would be some upfront pain in terms of paying a higher price in the interim to ensure the viability of the mine. They would in turn receive approximately 25 or 30 million tons to see them through to the end of the life of project of the Hendrina power station. Of course, I'm going to add, with the benefit of hindsight, it would have been an incredible deal for Eskom today. That's another issue. I'm going to jump forward. When the new management came into Eskom and looked at the cooperation agreement, it was their decision. They decided, in their view, that they could not pay a higher amount in the short term, and they wanted to end this cooperation agreement. They did not want to continue. They felt that they would take their chances in 2018, and it was their view that they did not have to continue. We felt it was unfair. We felt it was unreasonable. We explained it to them in the best possible terms that we could. We had meetings, we sent letters, we opened up the books of Optimum to show them the hardship. We showed them what was happening in the mine. Needless to say, we received a letter from Eskom, paragraph 36 of my first statement. It's page 9.
I've got it.
We received a letter on the 22nd of June where Eskom indicated that they no longer wish to participate in the settlement process and that the cooperation agreement essentially ended at that point in time. And we go on to say in paragraph 37, while Glencore and OCM understood that Mr. Molefe was entitled to his position and how that position might benefit Eskom in the very short term, that Eskom would continue to receive coal at low prices, we felt that Mr. Molefe's position did not necessarily appreciate the risk that Eskom faced after 2012, where they would have no security of coal supply for the mine, which was located very close to the Hendrina power station, and therefore would be in a very weak negotiating position. That being said, that was Eskom's response. And that was sent on the 22nd of June 2015. I now refer you to paragraph 39. The very next day, Glencore re-invoked and reinstituted the hardship arbitration. The very next day. At no stage was Glencore going to give up on the hardship. At no stage. So the allegations that Glencore wasn't going to go down the hardship road, there is absolutely no doubt in anyone's mind, including the members, including the directorship of Eskom, that Optimum was suffering severe hardship. Eskom made a decision. Eskom decided that this was not the road to go down. They didn't want to do a longer term deal for Optimum. They only wanted to worry about the short term. At the same time, there was a hardship provision. Had we gone down the road of arbitration, it could have gone either way. Of course, as arbitrations can always go either way, but we felt that we had a more than reasonable chance of succeeding in arbitration. And that's the crux of the story. Mr. Seleki, I'm sure I've touched on a lot of points that you want to you want to jump in on.
Mr. Ephron, Mr. Selega is looking at me because I asked the question. He's looking at me.
I can follow up.
Well,
it seems to me that you've become the evidence leader, Mr. Chairperson.
well, you might not be, you probably mean that well, but there may be others who would not mean it well.
I do, of course.
So the first time you invoked the hardship clause, was it 2013 or was it when was it?
Correct. It was 13th of July 2013.
Yes. And the cooperation agreement was signed when?
It was signed in...
Not necessarily the exact date, just...
23rd of... I've got the exact date, 23rd of May 2014.
Oh, okay, all right. So it might be fair to say there may have been around a year, close to a year or thereabout, when the cooperation agreement was signed, if you calculate from when you had invoked the hardship clause for the first time. Is that right? It might be less than a year,
yes,
but close to that, yeah. Okay, all right. Now you may...
Yes, and the arbitration proceedings were going ahead during that time. And I need to reiterate that Eskom approached OCM in early 2014. We only signed the cooperation agreement on the 23rd of May 2014, but early 2014, as per my paragraph 20, that's when Eskom approached OCM to suspend the hardship.
Okay, so are you saying that after the invocation of the hardship clause by OCM in 2013, the process that would have led to arbitration continued while discussions or negotiations were going on between OCM and Eskom. But before the arbitration could happen, the two parties concluded the cooperation agreement. Is that what you say?
Yes, after Eskom approached OCM, that's exactly what happened.
Yes, and then the cooperation agreement suspended the hardship clause, and then that went up to, is it 2015 when the cooperation agreement was cancelled?
Yes, 22nd of June 2015.
Yes. And thereafter, I think you said the following day, OCM reinvoked the hardship clause, is it right?
That's correct.
Yes. And before Mr. Selega asks you the questions he's going to ask, can you indicate to me whether when OCM reinvoked the hardship clause after the cancellation of the cooperation agreement, did that mean the continuation of the process that had been suspended when the cooperation agreement was signed, or did it mean invoking the hardship clause from the beginning? In other words, starting the process afresh? Or is that something you can't remember?
No. No, I can recall exactly. It was not starting afresh. Everything that had been done already from July 2013, we had just continued. In fact, we had set down dates for arbitration for a year hence, which was the 16th to the 27th of May 2016. So we were trying as much as we could to speed up the process. Of course, Eskom was trying as much as they could to slow down the process.
What then led to, why did the process not reach actual arbitration?
Because
in other
the
words,
company, because the company went into business rescue.
Yes. And that, of course,
The company went into business rescue later that year.
yes, that later in 2015.
Correct.
Yes. The company going to business rescue was, as I recall, OCM stroke Glencore's decision. Is that correct?
Correct. Well, it was all the shareholders. It was the shareholders of
other
OCH
Yes.
would have made that decision.
Yes, but
Not just Glencore.
Well, what I'm highlighting is that it wasn't a situation where some third party, maybe a creditor of OCM, initiated that. That was not the situation.
Well, there were circumstances. The board decision, the board of OCH and OCM would have made the decision, but it would have come as a result of circumstances within the company. So it wasn't from an outside party.
Yes, Mr. Selega?
Yes, thank you, Chair. I think
I leave a lot of questions to you.
No, that's fine. People must understand this is an inquisitorial investigation, Chair. So when you ask questions, you are not necessarily taking over from the evidence leaders. You're working with them. Mr. Ephron, I'm gonna let's see whether I'm not disturbing that sequence. But there's an issue here in regard to the hardship, the invocation of the hardship clause, and the referral of the matter to arbitration. That the knowledge on your part, and I'm putting a version to you from one of the witnesses, was that you could not prevail in the arbitration because of the reason why you invoked the hardship clause, which was the export market was down, and you had closed your export market component of the mine. The agreement specifically says in clause 27 that the downturn in the export market is not the reason to invoke a hardship clause. And I want you to comment on that, because if that was the reason, the allegation is that you then knew that you would not succeed in the hardship arbitration, and that's why you did not pursue it. Yes.
That's not the reason. The reason why the hardship was invoked was because the price escalation mechanism in the contract was not reflective of the current situation with respect to mining costs. And to be fair to the people that entered into this contract in 1993, there is no way that they could have envisaged that the price escalation clause could encapsulate all the necessary increases, or all the increases that incurred in mining from 2008 and onwards, and even before. And as such, every year, in real terms, the price that the mine was receiving was getting less and less as a result of the price escalation adjustment not being reflective of mining inflation. So what then happened was that the mine, as a standalone mine, or with the export product, was losing money. So it was losing money on the basis of the fact that this escalation clause was not representative. And for every ton that was being supplied, the mine was losing a significant amount of money.
What do
I
you
hope
say?
I'm answering you.
Yes, okay.
Correctly.
I thought you had not finished.
Well, I hope I'm.
We're coming out of that. Former Glencore CEO Clinton Ephron giving Eskom-related evidence at the State Capture Commission. You will remember that both former Eskom bosses, Brian Molefe and Matshela Koko, testified of some impropriety. Former CEO Brian Molefe placed the president at the center of an overpriced coal contract from Glencore, which apparently cost Eskom billions in lost revenue. Molefe said the president had a stake in Optimum Coal Holdings, which was owned by Glencore, and that Glencore relied on their association with the